Hello YouTube, I'm Vince White. I'm an employment attorney, and on this channel we answer publicly posted questions from YouTube users getting folks the answer they need from an employment attorney. We've got a question here from Aga Flaga Flaga Fluga. That is the YouTube username. And Aga Flaga Flaga Fluga says, let me read it into the record here. Okay. Hi, Vince. I'm wondering how to have a frank conversation with my attorney about settlement offers without being an asshole. This is the best question I've answered. This is a fantastic question. You are thinking. He wants me to settle for a number that would put less money in my pocket than what I've accumulated in lost wages, and which would completely ignore the extreme pain and suffering, which includes a diagnosis of PTSD with physical manifestations, severe depression, anxiety, etc., which I have endured. I don't think he's gone through the evidence I provided him, and which I organized for him with a beautiful spreadsheet, post-mediation, to prove the employer's arguments are lies. Plus, the office secretary told me the law office may be closing soon, adding, "There's a lot going on right now." That's very concerning. That is very concerning. I fear he wants a quick payday, but I want to give the benefit of the doubt and not be rude or unreasonable when he is advising me to settle. What are some ways to engage in a productive conversation about settlement offers? What are ways to politely push back? Okay. This is a top tier question. I think this question is going to help so many people, and this is why we answer questions, hopefully posted questions, but questions all the same. Because I would not have thought to make this video. So you, by asking this question, listen, I hope we help you, but you are helping a lot of people, I think. That might be hubris on my part, because I think my answer is going to help a lot of people. And yeah, I'm not humble. I wouldn't know how to be humble. Anyways, let's take it line by line. You want to have a frank conversation with your attorney about settlement offers without being an asshole. Great. You should not be an asshole, because this person should be trying to help you. You don't want to alienate them, right? So the situation is, he wants me to settle for a number that would put less money in my pocket than what I've accumulated in lost wages. Okay. Now pause button on that. Settlements generally hedge for risk. So you're going to say, like, listen, if you figure a case is worth, we'll just pick a round number, $1 million, right? Let's say you have combined economic and emotional damages, and you peg that number at about $1 million in valuation. That's what you think you might win at trial. Well, your settlement offer is not going to encompass all of that, because your settlement offer has to hedge for a risk. Your settlement's going to acknowledge that if you run that trial 10 times, you wouldn't win it 10 times. And there's not really any case, very rare at least, for us to be able to say that a case wins 10 out of 10 times, right? There's just too much going on in litigation, in this field especially, to argue that a case wins 100% of the time. The absolute best case can lose once or twice if you run it 10 times. So you're always hedging for risk, and hedging for risk looks like taking a little bit less than you might win at trial. Now you may say, Vince, I don't want to hedge for risk. I want to embrace risk and go to trial. Great. That's a reasonable demand. You're the client. You're the one who suffered. You're the one who calls the shots. You're the boss, right? So that's a perfectly reasonable thing to say, but that is different than saying, I want 100% of what I hope to win in settlement. That's probably not reasonable. That's probably a non-starter. That's probably going nowhere. And I think that's probably the only part of this entire block of text where I don't agree with you, right? And that's just listen, we're quibbling at this point. It's academic, right? Because everything else you're saying here makes sense. And you kind of go through, you touch upon all of the well-documented emotional damages that you've substantiated with treatment, and your economic damages. Fantastic. And you organize it all for this attorney. And you're worried that the attorney hasn't read that evidence yet, hasn't reviewed the evidence, hasn't digested it, maybe hasn't even popped open your spreadsheet yet. That's a real concern. That's a major concern, right? Now, we have a second major concern that only applies to you. So I'm going to deal with the stuff that only applies to you, and then I'm going to give general ideas about how to have this frank conversation. The law firm may be closing. Now, right off the bat, which I assume is a baseball analogy. I don't know. Right off the bat, that legal secretary, paralegal, whoever it is, I don't know that she should be telling you the firm might close. And I don't know that she should be telling you there's a lot going on right now. The attorney should be telling you that. If there's some kind of risk of the firm closing, it is your right to know, because you need representation and you need to make well-informed decisions about representation, right? So right off the bat, very concerned about that. If the firm closes, it's worth noting that you would presumably be freed of your lien, unless there's something in your retainer about some kind of transition clause or something like that. So I don't know if you paid this attorney any money, but if you're on a pure contingency basis, hopefully you would then owe this attorney nothing if the firm closed, right? There's also now the issue of, is your retainer with the firm or with this particular attorney? Is this attorney going to go to another firm? What's going on there? You know, check your retainer, know what your standing is, know where you're at in terms of what to expect. And let's see, you go on, you say, I fear he wants a quick payday, but I do want to give the benefit of the doubt and not be rude or unreasonable when he's advising me to settle. What are some ways to engage in a productive conversation about settlement offers? What are some ways to politely push back? Okay, this is the more general part of the question. This is the part that's going to help everyone. And I hope 7 minutes in that some of those people are still with us. Perhaps I should have given the general information first and then answered your individual questions after. But we did what we did. We're not gonna remake the video. Okay, so when I have a friend or a relative who has an employment claim, I don't represent them. But I do, very annoyingly, for the counsel my family retains, sometimes come to meetings or hop on calls, right, with the attorney. And they hate that because it's just having somebody second guess them, and, you know, they hate it. But also, you best do right by my family or my friend, right? So a lot of times what I'll do, because I share your desire to not be an asshole to the person representing my friend or you or whoever it might be, I'll ask why a lot. They'll say, listen, we think that you should open with a demand of, we'll go with $1 million again, $1 million. Then I just listen. Just listen. There might be some back and forth with my friend, my family member, whoever it is, which happens more often than you might believe. People love to sexually harass my family. And I'll just listen, and I'll hear the attorney out the whole spiel. I'll have a pad on my lap. I'll be jotting down things the attorney said. And the attorney will finally run down. They've given their whole statement. And the mark of an attorney who hasn't done this correctly would be that you need to then ask why. Why should I demand $1 million? Is that a positional demand? Is that a last best final? Do I expect that they're going to come to us and give us $1 million? In which case, the question is, why are we starting at $1 million if we expect that they're going to give us $1 million? Listen, the conversation could convince you that that makes sense, right? Like, listen, I know opposing counsel, we've said a lot of cases together. We're straight shooters. This is how we do it. I fully believe if I start with this demand of $1 million that she or he is going to give me the $1 million, because that's the smart play in this case. And I think going higher is going to frustrate their client more and make this more difficult and might maybe not get us to $1 million. You might agree, you might not agree. But you had the conversation, you heard the attorney out, and you can then make an informed decision as the client, right? But I hate the idea that I have to ask why. Why $1 million? Why why are we demanding a 50% hedge for risk, right? Like if we think the case is worth $2 million, why are we starting at $1 million? That almost nobody's going to answer up front. Nobody's going to lead with that because they're going to be telling you things you don't want to hear about your case. And employment attorneys, even the worst of us, even people like me with very, very light social skills, right, are going to come in and over time learn that people get really mad when you're like, listen, good case, solid case, valuable case, but there's some problems here. I mean, you shouldn't have told Chief Quimby that you wanted to date his sister. That's weird, and that probably made him mad, and that gives them an argument that he just hated you because you tried to date his sister, not because you protected class, right? That's hard to hear for some folks, and they're going to be like, you're turning on me. I don't trust you anymore. And that's not what's going on. That attorney's trying to be frank with you, right? Because you want to have the frank conversation in your own words, trying to be frank with you about the risk factors in your case. But a lot of attorneys don't, because a lot of clients can't handle the frank conversation. There's a lot of people where you go to them and you're like, listen, I love these 7 things about the case. This 8th thing over here, it does introduce some risk. And about 36 hours later, you will receive a threatening letter saying that you turned on them, you're on the take, you've been bribed, and you're trying to tank their case. What did you say? What? How did we get there? Like, literally, you can be like, listen, these 7 things are amazing. I love this claim. I think we should make a demand of $500,000 because you know, I love these 7 things about the case, but realistically, I don't think we can go for $1 million because there's this one risk factor, and I just think, you know, if we run the case 10 times, I think we only win it about, you know, half the time because of this risk factor. And I don't want to put up a goose egg for you. I want to put up a win. I want to put money in your pocket. And a lot of clients, super savvy, will really appreciate that approach. But a lot of employment attorneys just won't do that because you can say like, oh yeah, if you do that with a bunch of clients, most of them are going to be fine with it. Most of them are going to be fine. A couple are going to go over the table, try to fight you, like physically. A couple are going to literally spit on you. I get spit on twice a year, pretty much for the entire of my career. Like, you'll say something like, yeah, so you didn't tell us about the time that you ran around slapping people's butts. And that's going to really change the valuation of this case. And that person will just stand up and just spit on you. I guess they didn't want to hear that you shouldn't run around slapping people's butts, and it might change the valuation of your case by introducing risk, right? And a lot of horrible things will happen to a plaintiff's side employment attorney when they're honest about a case. So, first recommendation is ask why. Truly understand where they're coming from. Second recommendation, establish that you really want to hear. And just be honest. Just like, listen, it seems like you want me to take a lot less. And it seems, from where I'm sitting, I should. And I really want to know. I really want to hear you out. This is a safe space. I really want to hear you out. Why do you think I should take so much less than what I'm thinking here? And then just listen. Let them talk for as long as you can get them to talk. Hear all of it. Take notes. And as you take notes, I mean, these are things you're going to discuss further. You're going to drill down, right? Why should I take less than I think I should take? They're talking, you're taking notes. And be like, great, okay, so you mentioned 3 things that you believe mean I should settle the case for a lot less. Let's start with item 1. Have you gone through the spreadsheet that I sent you and looked at the related evidence? Because I think item 1, you're valuing that very heavily as a significant risk factor. But if you look at my spreadsheet, you'll see that I actually have 4 pieces of evidence directly on point there. And it's going to be pretty hard, if you've digested this material, to view that as a significant risk factor. Can you speak further on that? And listen, if that attorney says, I haven't looked at that yet, I don't love that. I don't love that. But relationship is still perhaps salvageable. You can say, okay, so why don't you look at that? And then we'll schedule a follow-up for that point. On to item 2. Item 2, attorney, I hear you. I haven't thought about that. That thing that you brought up for item 2, Okay, that is a significant risk factor that we should consider. Item 3, though, I don't think that person's a credible witness, and here's why. And you can have a conversation about that, right? And just go through it. Just line by line. Make it a list and hit each bullet point and have a conversation. And exit that conversation at least having heard the attorney out, right? And you might leave that conversation just be like, listen, I do not see eye to eye with you, attorney. We perhaps have to have a conversation about changing representation, right? We may need to. Or there's another way to go. Listen, I don't agree with you, but I still think you're a great attorney. So I appreciate your advice, but I want to go with my number. And if that means we have to embrace the risk of trial, are you willing to embrace the risk of trial on my case? And that attorney would hopefully say yes, but might sincerely just be like, no, I just think you're dead wrong. And you know, a lot of attorneys are going to be fronting or covering expenses for you, whatever it is. And they're going to be like, listen, this trial, like doing this trial for you is going to take us, I don't know, 200 attorney hours and 40 grand in additional expenses. And I got to tell you, you're dead wrong. You're not valuing the evidence correctly. You haven't done your evaluation correctly in terms of the damages. The risks are way higher. You don't really have the witnesses I'd want to see in a case like this. Client, I just think you're dead wrong. And I can't throw 40 grand and 200 attorney hours away because you don't get it. You've now had the attorney really respect you and really give you a safe place. It won't feel like it. It'll feel like they're saying you're an effing moron. But that's not what they're doing. They're saying, I trust you and believe in you enough as a client that when I have this frank conversation with you, I believe you're not going to try to murder me. You're not going to try to spin on me. You're not going to file a bunch of grievances against me, whatever it is. Come to my home in the middle of the night, stalk me, all kinds of crazy things happen, right? So what they're actually doing is giving you a ton of respect and hopefully giving you a straight answer. The problem is that really convincing case flippers will also be able to give the appearance of giving you a straight answer. That's tough. You're going to have to use your judgment to decide, hey, is this person bringing real concerns to the table? Is this person operating in a way to minimize my risk and maximize my value? Or is this person just trying to get me to take a settlement to monetize this case and get it out the door? And in your situation, monetize this case before the firm shuts down. Maybe, right? That's not generally an issue that people are facing. Firms shut down in this field because firms tend to be a little bit smaller. And for whatever reason, I've noticed that employment attorneys over the past 14 or 15 years of my career are just terrible with money. I think it's something to do with getting big checks for big wins. And then they just think they're going to have big wins every day. Like, I know a guy, I don't know, I think he runs like 60 cases a year. And he got one big win, I don't know, like 6 years ago. And he spent all of it. And he was like, well, I'll just have another big case. It's not a big concern. I was like, okay, but like you went like 5 years without a big case. You made money. You did well. You were comfortable. You made a couple $100K with your maybe even you made 7 figures. I don't know, with your 60 cases a year that you were running. But like, you didn't have any big wins. So why would you think next year you're just gonna have a big win again? And they will stare at you and they'll be like, because I'm that good. You weren't for the last 5 years. Like, I'm really glad you're good now. I'm really glad that you put up a big win for your client. I'm glad you got a fat check. But where was all of that for the last 5 years before this fat check, right? And they will just stare at you. Just like, and say things like, well, you seem to be doing okay. It's like, well, my firm runs a higher volume than yours. Like, my firm has a larger caseload with more attorneys. Like, it's a different, we're not running just 60 cases a year, So, yeah, we do tend to have a couple more hits along the way, right? Like a couple, also, frankly, my firm tends to have the pick of the litter in terms of the cases we get. So that's very advantageous for case valuations in a variety of ways. The cases tend to be lower risk, have higher value claims, have clients who earn more, so their economic damages are higher. These are all advantages, right? But a lot of smaller employment firms don't seem... They can understand those things for their clients and in their caseload and in their case valuations on an individual basis, but they don't seem to be able to do it in the greater context of the economic well-being of their law firm. And so you'll see things. You'll see things like an employment attorney buying a couple houses. Why? Why do you need a couple houses? You just had one good case, and now you bought multiple houses. You put down payments on 3 houses. You can only live in one house. What are we doing? Buying a supercar. Okay. All right. So statistically speaking, I mean, you bought a car that depreciates faster than any other car with the highest chance that you die in it. And you've spent, I don't know, $250,000 on it? Cool. Great decision making. Great decision making. Just top tier economic decision making. I've seen employment attorneys, one big win, and they go hire 6 associates. Okay. You had 60 cases. Now your associates have 10 cases each. You forgot you only originate 60 cases a year. You probably want your associates to have more than 10 cases apiece. Why did you hire 6 of them? What are you doing? What are you doing? And there just seems to be something where the kind of conflict-oriented people who get into this field and get really detail-oriented on a single case are also the kind of people who are not going to take a big picture view of their firm. They're going to spend their time fighting viciously on a case, getting every detail, getting the win, getting the check. And they're going to look up and be like, holy shit, I ignored my other 59 cases and all my bills and all the basic revenue, structure, profit margins, the overhead of my firm. Oh man, what do I do? And that's, so I'm not surprised. I'm not surprised to hear an employment firm is shutting down. And that is something, like, listen, firms that have lasted a while, firms that have been in existence and successful for a period of time, perhaps is something I should add to my how to evaluate an employment attorney playlist, because I see a lot of firms pop up, last for 2 years, help some folks legitimately, get some fat checks, and then crumble, right? So for you specifically, this guy shutting down, this firm shutting down, I don't love that for you, because it right off the bat says they're not looking to embrace trial. Even if your case was to go with this attorney when he leaves this firm, you probably don't want a solo doing your trial. Like a 1 seat at a trial is generally not ideal for a case of any size. You want at least a first and second seat, maybe a support crew in addition to that. Frankly, for a full federal litigation, I would not allow a solo litigator at my firm to single seat a federal litigation. Some agency hearings, you can do it. The scope of those cases is a little bit smaller. There's evidentiary rules that help the single attorney manage things. It just isn't appropriate for a federal litigation, in my mind. There should be first and second seat at a minimum and a support group. Now, let's get back to talking to the attorneys, right? Because we kind of addressed this thing specifically for you again. You went down your list. You went line by line. You arrived wherever you arrived. You arrived at, listen, I'm going to trust this attorney and take their advice, or I'm not. And if the answer was I'm not, you made a decision. Well, I would still have this attorney try my case, and I trust this attorney to effectuate my wishes so we can go forward. Or you decided, listen, I actually don't trust this attorney that much. I don't think I would want this attorney to try my case anymore. This attorney does not appear to want to try my case, or has told you flat out they do not. Right, now we got to take care of the lien, right? If you want a contingency basis with this attorney, or even some kind of hybrid where you paid something up front and you have a contingency on the back end, when you leave, they're going to say, okay, well, when you do settle the case, I still get my piece. And oftentimes, I've seen this out of just horrible attorneys recently, they'll say, well, we're owed everything. And you might say, well, you spent 10 hours in the case. What do you mean you're owed everything? I want my full percentage. I want my full, whatever it is, my third, my 28%, my 35%, my 40%, my 50%, whatever that firm is charging. And you're like, well, you didn't try the case. You didn't litigate the case. You only engaged in settlement discussions, and then, like, weird hair on the side of my head. And then you dumped me, or you told me you weren't going to try the case. So I don't think you should get the whole piece. If you can, have a settlement discussion with your attorney about, like, listen, okay, you spent 10 hours. Your hourly rate is, whatever, $500 per hour. So when the case settles, I think you should get, 10 hours times 500. I think that's fair. They might take that. They might not. They might fight you. If they fight you, listen, you can have your incoming counsel take care of it. You can go to fee dispute. You can have some litigation with them. There's a lot of things you can do. You can take it up with the Bar Association. That's all viable, but you do, if you can, want to get that squared away early for a couple reasons, including you don't want it hanging over your head. One. Two, you want to have that negotiation while the money is still speculative, because they don't know what they could have gotten, right? If you go out and you put up a win for 10 mil, and that attorney has been asking for, 35% of whatever you eventually get, they're now going to know that their percentage is 3.5 mil. They think, right? And they're going to become emotionally attached to that. So when you say, listen, I'll give you 10 hours at your hourly rate, they're going to say, no, never in a million years, but I'll knock off $500,000 for you. We'll take 3. Because they got the greedies. Attorneys get the greedies too, right? That's number 2. Now, number 3, as you're shopping around for counsel, they will often not want to take a case with a lien on it already. That can be detrimental. So there's a lot of reasons why you want to get this squared away and settle with the outgoing counsel early on, right? Hopefully you don't get there. Hopefully you had your frank conversation with the attorney and everything worked out and you were able to say, okay, we've agreed on a number for settlement that works for both of us. Although the client is the shot caller, right? Or we've agreed that we're not going to settle. We're going to stay high. The case is not going to settle, and we're going to go to trial. Whatever it is. Hopefully that's the path. Hopefully the attorney's good. The attorney's not trying to case flip. Whatever it is. I'm talking about, like, in a situation where you just don't want the attorney to do the trial anymore, or the attorney doesn't want to do the trial, right? These are important things. Also, it's worth noting, if the attorney does not want to do the trial, try to get that in an email, try to get that in writing, try to get that documented in some way, because it's probably going to be really valuable later on if you do have to go to a fee dispute or have some kind of dispute or litigation or arbitration about fees when they're seeking a lien on your case, right? Them declining to go forward is much more valuable to you than you saying, I lost trust in the attorney because they recommended a risk hedging strategy for settlement, and the fee dispute committee is going to be like, well, that's what settlement is. Yeah, settlement is hedging for risk. Of course they did. That's not a reason for them not to get paid, right? So those two things are very different, right? Often, people will come to law firms a lot and be like, I think you did something wrong on my case, so you shouldn't get your lien. Great. Show us. What did the law firm do wrong? And if you can show that to the fee dispute committee, fantastic. That's really valuable. By the same token, a lot of people, when their case gets settled, will come to a law firm and be like, well, I don't think you should get your piece because I don't think you did X, whatever it is. And the law firm can be like, well, funny you should say that. You don't like, your complaint against us is, hypothetically, we don't return your call fast enough. However, we have a call log system And over the 3 years of data that we represented you, let's go be more realistic. Let's just say 8 months. 8 months of data that we represented you. It appears that on average, every time you call us, you received a call back on weekdays within 28 minutes. And when you called on the weekend, you received a call back in the first half of the day on Monday. So, you know, we're a law firm that does this for a living, and we're well aware that sometimes people want to wiggle out of liens, wiggle out of their contingency, so we keep that data. And so you're a liar, liar, pants on fire who's got the greedies, and we can prove it because you're a moron, right? That happens. That's very, very common. I don't even register it anymore. When, you know, like, people will come in and be like, you don't call me back fast enough. And you'll pull up the system, and it's like, you have a 14-minute callback on average. Like, what did you think was going to happen? Were we going to bend space and time? Like, were we going to call you back before you called us? Which, frankly, we actually also do, right? Like, there's automated step-based, like, this happened, the client gets a notification explaining what happened. There's monthly notices, status updates, everything goes out automated. So there's also affirmative outreach before the client contacts us. But even that's not what the client was saying. The client wasn't saying there was poor communication. The client was saying specifically the response time was poor on these, like, hypothetical phone calls, right? And it's like, no, we have proof. We have a log. We have a system that tells us the response time, in part so that we can keep an eye on our own staff and make sure that we're living up to the level of representation that we want, right? But also in part because people, they lie sometimes, right? There's people with great cases who have been horribly wrong, who one day wake up and decide to lie about something because they don't want their attorney to get a piece of the case anymore. That's okay. It doesn't mean they weren't horribly wronged. It doesn't mean they don't have a case. It just means you have to have the proof. You shouldn't get mad about it. They've been through a lot. I get it. Sometimes I get it. Sometimes I get a little hurt by it. I try my best. To put it in context. Be like, well, this person's been through a lot, right? So yeah, if you can, deal with the lien, and if you have a legitimate grievance against the attorney, if you have a legitimate reason why the attorney is failing you in some way, or if the attorney is telling you that they don't want to do some key part of your case, like the trial, that's very valuable to you and will help you defeat all or most of that lien, hopefully. Okay? Aga flaga flaga fluga. How did I do? We're at 32 minutes. I feel like there's so much more I could have said. I do think I was a little bit all over the place in this video. I have so many thoughts about having these frank conversations between attorney and clients. I could and perhaps should talk about this for hours. So everybody, if you made it this far in the video, comment down below. What else about the attorney-client conversation around settlement should we touch on? What have you experienced? What are your concerns? What tactics did you use? What do you want to know? What are you wondering in terms of what the attorney's thinking, what the attorney's doing? How is the attorney evaluating? Like, what value on this topic can I deliver for you? I think this will probably be a new playlist. I'm just gonna call it like frank settlement conversations with your attorney, I guess, because aga flaga fluga, that was you phrased it in such a great way. And yeah, I just, in the comments, let's build this one out. Let's collectively as a channel just pepper this with questions. This is where so much tension in our field lives, right? This is, and it shouldn't be, but this is where it's a major pain point for clients in this field. And part of it is legitimately that, listen, there are case flippers in the field nonstop, and that sucks. But also, listen, there's great attorneys who have a lot of pain with their clients on this same topic. And if we can do something to bridge over those troubled waters, build a bridge over troubled water. Nope, that's not how the song goes. Also, I can't sing. But if we can build that bridge, if we can build a bridge over those troubled waters, we should do so. This might. You want to hear how egomaniacal I am? I was about to say this might help the whole industry. I'm mentally ill. I am not. I have an ego problem. I like so much narcissism. Not to self-diagnose, but like in that moment, I was like, I can make the whole world better with one video, with one playlist of videos. I can make the whole world better. Woo. Woo. All right, we're gonna end there. Like, subscribe, comment down below, share the channel so it can grow, and hit me with the questions on this topic down below. So let's build out that playlist. Take care.